All right, Tony, let's go on the record on cause number DC 206842 in Tom LLC versus Tahoe We Go 1 LLC. Counsel, make your appearances.
Morning, Your Honor. Ruben Garcia from Lynn Pinker, Hurst, and Schwegman on behalf of a defendant, Kaylee McMahon and Tahoe We Go 1 LLC.
Kunal Udeshi here for plaintiff Jana McCoy. And in Tom LLC.
Well, great. Let's go ahead and proceed.
Okay, thank you, Your Honor. This morning we're here on our motion to quash, and we're respectfully requesting that the court grant the motion to quash, which is for a notice deposition of Ms. Kim Crawford, who is a CPA at Sutton Frost Carey LLC. She was engaged jointly by the parties as part of the settlement agreement, and therefore any testimony she may give is inadmissible under Rule 408, and likewise is not reasonably calculated to lead to the discovery of admissible evidence. Stepping back a bit, in August of last year, the parties participated in a mediation that resulted in a Rule 11 and settlement agreement. And as part of that settlement agreement, the parties were committed to engaging a CPA or auditor to review the financials of the companies and give some opinions and a report about what the findings are about any spending that might have occurred. Ms. Crawford, who the plaintiff has noticed for a deposition, is the person who was chosen jointly by the parties. Her engagement would not have happened but for the settlement agreement. She's never had any previous dealings with the parties. She never had any previous dealings with any of these companies. She hasn't had any dealings with the parties since her role in creating the report. So any opinions she has made or any testimony she will give will be inadmissible under Rule 408, which, as you know, prohibits the use of conduct or statements made during compromise negotiations. Had defendant known that Ms. Crawford's financial reports would have been used by plaintiff for any support, either in motions or at trial or at a deposition, she obviously would not have done this exercise jointly with plaintiff. The standard procedure would be for each side to retain their own expert, provide opinions, and then we could, hash that out in motions and at trial and try and narrow the issues. But plaintiff here is essentially trying to circumvent that whole process by taking advantage of work that was done as part of and consequence of a settlement agreement. Plaintiff cannot use to her benefit the reporting that was done as part of settlement negotiations. That's exactly what Rule 408 is for. It allows the parties to engage in joint efforts to resolve their issues without the threat of those discussions prejudicing for future positions that they might have. Nonetheless, plaintiff does argue in their response that 408 should not prohibit the deposition because the rule doesn't protect pre-existing information. The problem is Ms. Crawford's report, any testimony she will give, did not pre-exist the settlement negotiations. It was because of the settlement negotiations that they exist. Now, of course, the financial documents that Ms. Crawford received from the parties and also that pre-existed the settlement negotiations are admissible, and those have been produced as part of discovery in the case, and plaintiff is free to use those and retain whatever expert she needs to try and make opinions out of those and file motions off of them. However, she cannot go out and depose the jointly retained CPA to provide opinions in support of her case.
So how did the CPA end up getting picked? Was it part of a settlement discussion? I don't think it was an order of this court. How did the CPA end up doing this?
Correct. So the Rule 11 settlement agreement, paragraph 1 says the parties will jointly engage a CPA auditor to review the financials of the company and provide a report within 30 days. And so in accordance with that settlement agreement, we jointly engaged, we both agreed, and I'll admit the attorney that's representing plaintiff now is not the attorney that was in these negotiations. He's been replaced. But we agreed that we were going to jointly pick someone and they were going to provide a report and we were going to try and work it out from that. So that was how her engagement came to be.
Okay, response?
Judge, first of all, I filed a written response to this motion to quash. I don't know if the court has had time to review it.
When did you file it? I didn't see it in the system.
I believe it was like 3 days ago. I believe it was like Monday, Tuesday.
Let me see. Ah, okay. It wasn't included in my, okay, let me look at it real quick. Okay. Is there any case, it's kind of an interesting situation. I've never had this really come up before.
If I may, Judge, if I may as well, just to kind of summarize our position here, we believe that Mr. Garcia is mixing two issues of law here, one having to do with work product and the attorney-client privilege, and the other having to do with settlement negotiations. The fact is that there was a mediation that occurred, and there was a negotiation that happened during that mediation. Nothing about that negotiation, we're not going to the mediator and saying, hey, what did they say in this negotiation? The negotiation resulted in an agreement to have a report prepared by an independent third party. None of that is protected by any kind of privilege. None of that is part of the negotiation. The agreement is that a third party auditor would come in and create a reconciliation, and that reconciliation would be done in 30 days. And at the end, if the respondent owed money to the companies, that she would repay it. The report was made, the number was identified, and the respondent failed to make that payment according to the agreement. Now the respondent is claiming that the number is not correct, that the report is flawed, and we want to be able to depose the person that conducted it so that we can find out, what were the basis for her opinions? How did she come up with it? And we're entitled to it. We are entitled to conduct our discovery however we see fit. These are, even if the court later determines they're inadmissible, this is not anything that's privileged by any kind of attorney-client privilege. We're entitled to ask these questions and get our information.
Your Honor, if I might respond.
So the question I have, are there any cases that address this type of situation?
Your Honor, I did some research on it, and I could not. And I would venture to say that it's because this is very clearly part of a settlement negotiation. My client would not have signed a settlement agreement that called for some report that could then in turn be used against her afterwards. That's the whole point. Had we known that they would have revoked their decision to agree to some agreement and then turn around and use the information that came out of the 408 settlement agreement, we wouldn't have done it.
This happens every day, Judge, in family law cases. I mean, parties go in mediations and agree to have an expert conduct a report about a custody evaluation, and that report is provided to the court. I mean, this is not something that's new for parties to go into settlement negotiations, agree on an expert to conduct a report, and then present the report for use at court. I mean, there's no way my client would have agreed to this had she known she wouldn't be able to use it. It cost money and took time. There's no point of doing this unless it was for the use of court. The engagement letter says that it's for the use of court, and that she also outlines what her testifying rates are. there was no, and anything that was turned over to her.
So let's turn to Rule 408, because that's really what we're dealing with here, right? It's Rule
Right,
408.
Judge. Exactly.
And so 408 covers compromise offers and negotiations. A is prohibited uses. Evidence of the following is not admissible either to prove or disprove the validity or amount of a disputed claim. 1, furnishing, promising, or offering, or accepting, promising to accept, or offering to accept a valuable consideration in compromise or attempting to compromise the claim, and conduct or statements made during compromise negotiations about the claim. B, under 408 says, the court may admit this for another purpose, such as proving a party's or witness's bias, prejudice, or interest, negating a contention of undue delay, or proving an effort to obstruct a criminal investigation or prosecution. And so I guess in my mind, I mean, generally settlement discussions and agreements are not going to be admissible unless they're admissible under 408B. And so I understand going back and forth on this, but I really feel like there needs to be some type of discussion of the, which I don't think it would come under proving a party or witness's bias. I don't think that prejudice or interest, I don't think that would come in. Negating a contention of undue delay, I'm not sure if that would apply. I don't think it would. And the criminal investigation or prosecution. And so I guess my question is kind of to the defense attorney is, what exception to 408, the general rules of 408, does this fall under?
Do you mean the plaintiff, the one seeking the depo, right?
The one seeking the depo.
So Judge, I would say that these aren't even part of settlement negotiations. The settlement negotiation ended with the agreement to do a report, to furnish documents, and to engage a CPA to do a reconciliation. This was an independent, not sought out by one side or the other. This was not a settlement negotiation that they were engaged in. This was not an offer for compromise or an offer for settlement. This wasn't saying, hey, instead of $10, I'll settle with you for $5. That's what the rule protects, is someone coming in there and saying that they offered me this during our settlement talks, or they said I would do this during our settlement talks. This isn't what this is. This is a report created as part of the agreement. So the settlement talks ended at the mediation. And this was part of the agreement that was formed at that time. I think that rule, and in our response, we identify that what the purpose of that rule is, and it's to protect the ability to close cases out and to negotiate in good faith. So if you're
but wouldn't that really apply here? Is that wasn't that the effort here was to try to reach a final settlement of this?
No.
Auditor, sir, let me finish, please. Isn't the issue really here that there was an effort to try to get an auditor in here to determine the amount of damages, I guess, or the value of the company or whatever, which would not have occurred but for the settlement agreement?
I don't think so, Your Honor, because everything that was part of the reconciliation was discoverable. And the parties agreed at the mediation.
I agree with you that if there's information that was produced that would be otherwise discoverable, I think that is, part of the rule, although that section was, I guess, deleted at some point. I'm reading a commentary on 408. I do think that you can't cloak otherwise discoverable information, for example, including something in the settlement agreement that would be discoverable, and then say, hey, this isn't discoverable because it was included in the settlement discussion. I don't think the auditor's report fits into that, but I haven't, again, that's why I keep asking, is there any case law on this? And it doesn't sound like either side really has any case law on point. Is that correct?
That's correct on my side, Judge. But I would say that this is a secondary consideration, that the admissibility or inadmissibility of this evidence should not bar our right to conduct discovery on this witness. Discovery and depositions have to do with anything that could lead to admissible evidence. Anything, if there is something that's barred by 408, it does not bar it for a deposition. It's just
So by that discussion, by that analysis, I guess, taking the deposition of a mediator, even though that's clearly not going to be admissible, your argument would be that that would be permissible because doesn't go to the issue of admissibility?
No, Judge, no. So the rules on mediation are clear. This did not occur during a mediation. Again, I don't see the auditor's role as someone that was conducting a negotiation. I see the auditor's role as somebody that was gathering information and creating a report that was to be used by both sides. And I think that, there's nothing in the agreement. I've attached the agreement to my written response, the mediated settlement agreement there. And there's nothing in this agreement that says that this is to be done just for negotiation purposes, or that, this is not to be admissible or anything of that sort. In fact, at the end of it, there is a provision. Hang on.
At this point, what I think I'm going to do is just, I'm going to grant the motion to quash, but without prejudice to you to do some additional research about Rule 408. I'm looking at a treatise on Rule 408, and I don't see anything, in kind of a quick look at this that's right on point. So I think at this point, I'm going to go ahead and grant the motion to quash. But if you want to, brief this and try to find some cases that say that this type of situation is not covered by Rule 408, I'm glad to reconsider. All right, guys.
Thank
you, guys. Did you submit an order for that?
I believe I did, and if I didn't, I can send it immediately after this.
Let me see. I see a proposed order. Let me see.
Yes, Your Honor, it is on there actually.
Okay. All righty. Well, I will go ahead and try to get this signed today, and we will we'll go from there.
Okay. Thank you, Your Honor.
Thank you, guys. Okay, do we have the folks in the next hearing here? Is there anyone here on the next hearing?
Good morning, Your Honor. This is Robert Collins. I'm here on the 10 o'clock docket. I'm a little early, so I don't know if you're still handling earlier matters.
Let's see, there's a 9:30 hearing. I think it's called, let me see. Interflow versus Duradia. Anyone here on that one? Okay. Mr. Leonard, what are you here for? Well, okay. Mr. Smith, what are you here for, sir?
Good morning, Judge. I am here on the Granger versus Pilot Travel Centers. It is a motion to enter scheduling order, Judge.
Okay.
Your Honor, that's the same matter I'm here on.
You guys have an agreed scheduling order on this?
No, Your Honor.
Okay. All right, so first off, let's kind of figure out, when do you want to set this case for trial?
Judge, I have proposed, considering the reality of getting this case in front of a Dallas County jury, I have proposed an April 2022 trial date. Counsel has provided a shorter period, but I just really think it's unrealistic considering where we are. And my position is, why do we need to keep coming back asking for an additional scheduling order when we have the latitude of time to continue working on the case? So I have proposed, I think, a more realistic trial date of April 2022, which is only 18 months, I believe, Judge.
All right, a response?
Thank you, Your Honor. Your Honor, there's really just two issues before the court. We proposed an October 2021 trial setting. To be quite frank with you, Judge, I'm less concerned about the trial setting than I am about the other issue that we have in dispute, which is the only other issue that we really have before the court this morning, is we want 30 days between the plaintiff's expert designation deadline and our expert designation deadline. At this point, the plaintiff is unwilling to give that to us and is only willing to provide us 14 days. You know, if this was a level 1 case, if they were claiming, less in damages, if it was a minor fender bender, I would be less inclined to fight that issue. But they've pled it as a level 2 case. They're asking for more than $1 million in their pleadings. It's an assault case. And in their petition, they go out of their way to say the guy was knocked unconscious. So in my mind, I see potential traumatic brain injury claims, which is going to require definite expert testimony, possible evaluation of the plaintiff. And so I just don't think 14 days based on what their pleadings or have been alleged is reasonable. And in that regard, I'd also use the same argument. Where's the harm in giving us another 16 days, especially if the plaintiff is, wanting to kick the trial all the way out to April 2022. Again, I'm not really concerned with the trial setting so much as I am the expert designation deadline issue.
Judge, may I respond? Sure. Judge, I used the exact form promulgated by the Dallas District Courts. I did not change any aspect of it, and I have requested counsel that we should follow the direct suggestions provided by the Dallas District Courts. And that's just my position. If the courts see fit to allow 14 days for the defense experts, why am I going to argue with that? And that's been my position all along. If you'll look at the dates, you can pull off the Dallas County website, Judge Boyer, all of the other courts. This is the exact form that they have provided for litigants to utilize on level 3 cases. And I simply believe that we should follow your instructions. And that's my position. I don't want to change it without input from the court. And I think counsel will agree with me. That's exactly what I told him. I don't think we should have the latitude to change that. And if there's going to be a disagreement regarding such,
Did you use, so we had the 68th, this is the 68th District Court. We have a one that we have on our website. Is that the one you used, or did you use one that Judge Moyer does?
May have been the one off of Judge Moyer. And if there is one
this is the 68th court, not the 14th. So you know, you can do whatever you want. It's just mine is just a recommendation. I'm not familiar with his, so I don't know if that's if his is the same as mine or different than mine. So you know, and I don't have a strong opinion either way. You know, I generally on level 3 cases let the parties kind of choose their deadlines. His might be identical to mine as far as I know. I just, it does concern me a little bit. You're using the different judges.
I apologize. Here is what I have no problem stipulating to, Judge.
Mhm.
I will follow the recommended uniform scheduling order level 3 provided by your court. I was under the assumption that they were all the same. And
Yeah, they might be. I don't know what his says. He has, you know, we all have different idiosyncrasies, and so his may be identical to mine. Mine is one that's been around since, you know, I don't think I've changed it at all since I started actually as a judge. So it's pretty standard, but I don't know if his is the same or not, or how he's done his, if it's identical or not.
And I don't want to offend you. I apologize. I think my intent was to use the one provided by your court.
Okay.
So I wasn't looking around shopping for different uniform scheduling orders just to suit my intent. I really just thought they were essentially all the same. So if the court is saying that we can rely upon the one provided to us by your court, then I will abide by those schedules. And that's what I would like to do, Judge.
Mr. Collins. Yeah.
You know, my understanding is all of the forms that are provided for the court are, you know, best practices, recommendations, and parties can agree to modify anything that doesn't affect the court's trial, generally, that doesn't affect, you know, any deadlines, self-imposed deadlines from the court. And so again, I have no objection to starting out with using the court's general order as a starting point, but you know, every case is a little bit different. And like I said, this isn't it's clear from their petition that there's a potential for an alleged traumatic brain injury here. And so I'm erring on the side of discretion and just asking for my 30 days now, because what, you know, if we move forward with a 14-day deadline and it turns out that I'm going to need these experts and they're going to need another expert's data or other information, how would we be able to get that issue potentially resolved within the 14 days? You know, I'm just trying to resolve an issue now before it even comes up. And again, whether we have an October trial setting or an April trial setting, you know, it's an additional 16 days that we're asking for, which is not unreasonable.
I'm trying to find mine online just to see.
I'm actually I'm doing the same thing, Judge.
Yeah, Louise, you know, it may be something that you would need to get from Rhonda. I thought we had our standard orders on here.
The rule I see, it says the court does not require a specific scheduling order, but can provide a sample one if requested.
Judge, I think that's the whole reason for the court providing us a proposed scheduling order if we can't reach an agreement. And I think—
Why don't we do this, just to kind of move this off a dead center? Why don't we pick a trial date? I'll have Rhonda send you guys both a copy of what we have. Do you mind grabbing Rhonda real quick? And if you still need some additional assistance from me, you can do that. But we do need to pick a trial setting. That is kind of key here. I agree that October is not realistic. I don't, you know, you could move it anywhere between February and April next year. I still don't know if those are realistic, but you know, they could be at least. So when would you all like to do it?
Judge, I have proposed April 8th, 2022. I think that's really more realistic considering what we're dealing with. And we may at that point even have to ask for an additional trial date that's pushed out further. But right now, I think my suggestion is more realistic.
Your Honor, we're
Mr.
fine
Collins
with,
doesn't seem to oppose that.
Your Honor, we're fine with an April 2022 trial setting. I think you're
April
right.
8th
It's
to
unlikely
Tuesday.
we- What's that?
Is that a Tuesday?
Judge, I apologize. That needs to be April 26th, which would be a Tuesday. April 8th is a Friday. I apologize.
Of 2021 is a Friday?
2022 is a Friday.
Sorry, 2022, yeah. So, yeah,
April
just,
11th is a Monday. April 4th and April 11th in 2022 are
so
Monday.
you want to do it on a Tuesday, so you said April 11th, so April 12th or April
5th.
5th?
We're
Yes.
fine with either one of those, Judge.
So Judge, April the 11th or April the 12th, I'll go ahead and
Sorry,
change my,
April the 5th or April the 12th?
okay, April the 12th. I'll go ahead and put that, I'll change since I have the form already loaded up.
Oh, sorry, just one second. So did you guys decide on April 5th or 12th?
Well,
12th.
That's
All
fine,
right.
Judge.
Go ahead and set this for April 12th, and then Rhonda's going to send you a sample order through email. Okay, guys?
Thank you, Judge.
Judge, again, I apologize if I just happened to take the one out of the 14th. No offense was made.
No problem. Just, I just don't know if it's the same as mine. If it may be exactly the same and it's no big deal. It's just, I just wanted you to, but I don't want to, I just don't know. So that was my only concern.
All right. Thank you.
Thank you.
Thank you,
All right.
Judge. May we be excused?
Excuse.
You may. Okay. Anyone here on Maya Walnut versus Brian Lee?
Yes, Your Honor, Mary O'Connor for the defendants.
Anyone here for the plaintiff? Are they here? Is Mr. Leonard, or what are you here for, Mr. Leonard? Is Mr. Leonard your opposing counsel?
Oh, no, it's Ira Bowman, Your Honor. It's his motion today.
I see IT support for Ira Bowman, but they're not, they're unmuted, they're muted. And then there's a Brian here and there's a Derek Leonard. Are any of those?
No, it should be Ira Bowman and Grace Lee.
Mr. Leonard, what are you here for, sir? Can people hear me okay?
I hear you, Your Honor. I believe that Brian is my client, Brian Lee, who's one of the defendants.
Okay. And you don't know who Mr. Leonard is?
No, I don't.
The other folks are either interns, or court staff. Well, I'm not sure what to do. Mr. Bowman, are you there? It says IT support for Ira Bowman, but it's not working. And Mr. Leonard, I don't know who that is. Well, I'm going to put in something in the chat to everybody. Okay, there's Mr. Bowman again. Mr. Bowman, are you there? You're muted, sir.
Yes, Your Honor. I had gotten a notification that you were running behind from Ms. Balderrama, but so that was why my camera was off. Sorry.
Okay. That's okay.
I'm gonna go grab my jacket off the door if that's all right.
No worries. Let's go ahead and get started. This is on the Maya Walnut case.
Yes, Your Honor.
Let's go. This is a summary judgment. Do you guys want this on the record? We don't usually put those on the record, but we can.
No, I don't need a record, Your Honor.
No, Your Honor.
All right, let's proceed.
Very good, Your Honor. Ira Bowman and Grace Lee are here on behalf of the plaintiff, Maya Walnut. And we are moving for summary judgment, Your Honor, on the defendant's counterclaims. I have a PowerPoint for the court's review. If I may have our IT department put it up.
Sure, give me 1 second. All right, let's go ahead and proceed.
Thank you. Bernard, will you please pull up the PowerPoint? Very good. If you'll go to the next slide, please, Bernard. Your Honor, a brief timeline of the key events. This is an old lease that we are being sued under as a counterclaim. It reaches back to 1963 for an old grocery store. And then over the years, it was modified and then entered into ultimately in 2008. The key aspects of it, though, are that there was the original lease agreement for Safeway in 1963. And then in 1978, there was a modification, which is what defendant is claiming gives them the right to their breach of contract. On October 15th, 2008, the assignment and assumption of the lease took place, wherein my client became the tenant and began operating the grocery store there. The time frame that is being complained of is from 2017 until 2019 under the lease agreement, saying that the calculation of percentage rent based on the definition of gross sales in the 1963 lease was wrong. The defendant countersued in September of last year for 3 causes of action. One is for breach of contract for non-payment of rent, specifically the percentage rent. The second cause of action purports to be some property damage. I'm still vague on exactly what the cause of action is there because the contract itself does not seem to have a provision that they rely on, and although they say that their claim sounds in contract, although we'll get to that in a minute. And then finally, fraud by non-disclosure. So I would like to move on to the next slide and focus on the breach of contract claim. Really, this is absolutely a matter of law situation. It's an interpretation of the contract. That's all that it is. What they are saying is that the 1978 modification changed the 1963 contract, and I will certainly blow this up for Your Honor. If you, Bernard, will pull the paragraph that starts with the word first on the right side so that we can understand what the modification is. So this is the provision that they are saying modified. Now, the problem is that it says notwithstanding the provisions of Article 2 of the Safeway lease and the Super S lease. The difference between the Safeway and the Super S is they're the same terms, but they started out as two separate leases. They got combined. That's not an issue, but that's why they are both identified. However, it's the Article 2. So notwithstanding the provisions of Article 2 to the contrary. So what is Article 2? All right, Bernard, if you'll take that away and go to the top of the left-hand side, this is the 1963 lease. Article 2 at the top is the rent. And the rent has defined terms throughout it. If you, Bernard, now will take that away and go to the lower section and blow up the third big paragraph. Under rent, there are certain defined terms. In this case, the key defined term is gross sales. And apologize if it's a little fuzzy. However, the key aspects of gross sales in this particular instance are the, and I apologize, but my screen is blocking my view of the document. There we go. Sections 5 and 6, obviously this is a going on 60-year-old lease, so the language is a little different than we might use now, but it's certainly broad in its intention and concept. And what it says is, as gross sales, it shall not include any of the following. 5, the net amount of discounts allowed to any customer pursuant to any customary and reasonable policy adopted by lessee, including in such discounts, but not by way of limitation, the net amount of any discounts allowed by way of or resulting from the issuance to the customer of trading stamps or other evidences of purchase for immediate or future exchange for merchandise or other things of value. And 6, the dovetail other end of that, merchandise or other things of value issued in redemption of such trading stamps or other evidences of value, or issued as a premium or otherwise in connection with any sales promotion program of lessee. Take that down now, Bernard. The importance of that is that the term gross sales in the 1963 lease included the concept of these discount programs. These discount programs are what my clients withheld the rent based upon. That's undisputed. The rent that was withheld was advertising income for what were called circulars. They were circulation promotions, so that if you sell one bunch of bananas at under cost in order to bring the customers in so that you can sell them the box of cereal they're going to buy with the bananas at the actual cost. The purpose is not to punish the tenant for selling something at under cost at the discounted rate. That's the whole purpose of the promotional aspect of excluding from gross sales those types of sale events. That is what is at issue, is what was withheld. The actual change that occurred in this lease modification, because the question then becomes, all right, if it's notwithstanding anything to the contrary, what was actually changed? In this case, you can see in what the minimum rent was down in 1978 included, now it added in taxes and certain common area maintenance lighting into gross sales, but that did not change, or excuse me, into percentage rent. But that did not change the definition of the term gross sales. In fact, they used the term gross sales in sub B, again, not changing its definition. It's used in the same manner as the document they are modifying. So it's calling back the fact that this is already a defined term. So it has not been changed, and the interpretation of it is a question for the court. It is undisputed that what was withheld was this advertising income. So the only question is, does this definition change in 1978 or not? And we don't believe that it does. The next aspect, Your Honor, I apologize, I have one more call out. The reason that it does not change is call out 1B, if you will, Bernard. The 1978 provides that this 6th paragraph, except as herein modified, all terms and conditions of said lease shall remain in full force and effect. So the 78 lease does say, unless we changed it, it's the 63 lease. So that is obviously an important aspect of the 78 modification. So moving on now, Your Honor, to the issue of the property damage. Bernard, if you will go to slide 4. Again, we claim that they don't state a cause of action. I did not find a cause of action that they were exactly relying on. They say it sounds in breach of contract, but there is no contractual provision that they cite to regarding the property condition. However, irrespective of that, there's no evidence that any of the damage that they claim was material or permanent, because the new grocery store that was going in was always going to update, change, and make with the interior of the space its own. That's obvious. They're changing a significant aspect of the grocery store, which they did. So I don't believe there's any evidence that any injury was material or permanent, and there's certainly no competent damage evidence. The only evidence of damages that they submitted, which we object to, is the speculative and conclusory statement by the landlord of a guesstimate of his amount of damage, which I don't believe is competent damage at all. And then they submit some letter that they purport to say is a damage demand. However, it is unauthenticated and it is hearsay, and they do not get around either of those objections. So we do not believe that they have stated a cause of action, but if they have not submitted competent evidence of damage in that regard. The last claim that they have, Bernard, slide 5, if you will. Defendants their suit for fraud it's really just an attempt to backdoor their breach of contract. It's the exact same thing. They say that there was fraudulent non-disclosure of the fact that we were withholding the income from the advertising income from the rent payment. Well, I mean, it's axiomatic in Texas that you can't fraudulently breach a contract. If we were breaching the contract by withholding rent amounts, then that's what we did. We breached a contract. If not, you're not committing fraud by doing that. You don't commit fraud, irrespective of your intention when you breach a contract. So, I mean, fraud's all about intent. We all know that. You intend to have the person rely upon your lie. In this case, if it's a breach of contract, the intent doesn't matter. There's no fraudulent breach of contract. Moreover, if you look at the non-disclosure concept, what is it that they're saying was non-disclosed? It's not a suit for fraudulent inducement into a contract. It's suit for fraud of non-disclosure. The non-disclosure being every time they paid the rent, they're saying we fraudulently withheld the parts that were the advertising income. Well, that's not material to any aspect of our relationship. Our relationship exists as a tenant and a landlord. That's subject to a contract. And if you're saying what we did was wrong because we didn't pay the rent, well, that's a breach of contract. That's not fraud. So they do not have a claim for fraud in any way, shape, or form. They cannot establish any reliance of any kind other than to say that they were continuing to be the landlord. Well, that's not reliance. That's a contractual obligation that they had. There is one section that they say that they're trying to suggest that somehow non-payment of the income of the advertising income allowed the defendant to have us hold over for a month. The holdover was separately negotiated and it didn't have anything to do with payment of income rent, and it's only a month, so they can't establish any damage from that amount of time that was being done. So I mean, their claim really is we should get all of our money back for the time in memoriam that we didn't get paid this advertising income. Well, that's not fraud. That's breach of contract. And again, we do not believe that it is breach of contract because the contract specifically allowed us to withhold these rents. That's what its whole purpose was. So, and again,
sounds good. Anything else?
Yes, Your Honor. On to the next slide. As it relates to the purported expert that they included in their response, he's apparently an accountant. So to his damages opinion, frankly, it's one or the other. It's either irrelevant, truly irrelevant under the expert rules because he's not providing the court with any aid to any material question that the court cannot otherwise answer itself. And that is, he's irrelevant if what he is saying is what the typical definition of gross sales is. He is, and if what we're talking about is a typical definition instead of what the contractual definition is, then that's irrelevant. However, if he is trying to opine as to what the actual definition of gross sales is in this instance, well, then he's offering a legal opinion and he's intruding on the province of the court. And in that case, we do have case law, Your Honor. If you will call out for Bernard, please, the Barrow Shaver case from the Supreme Court of Texas, 2019. The court was very clear, obvious. When a contract's unambiguous, you do not consider outside evidence, including custom and usage, to alter the terms of the contract. Allowing that would give the jury an opportunity to create an ambiguity, in this case, the court, where none exists, or alter the terms of the contract's clear, unequivocal language to the party's obligations. This is a very straightforward situation of this. So if you would see what his actual opinion is, call out 9 briefly, real quick, Bernard. Again, he says that it's his opinion that the term gross sales typically includes revenues. And it's his experience in accounting that gross sales also typically includes. Typical inclusion is irrelevant when you have a defined term in a contract. And so that's what we believe. He is either irrelevant under the rules of expert witnesses, or he is offering a legal opinion as to the definition in this case. I don't believe he actually takes the next step and says what the definition is under this contract. I think they're just trying to make his suggestion alter the language. But we believe that his opinion is, in that case, something that should be stricken by the court and not relied upon. In addition to that, we also, if you'll go to slide 7, object, as I said earlier, Your Honor, to Mr. Lee's declaration about the damages. Again, he is doing nothing but speculating. If you'll put it up real quick, the call out 6B, Bernard, it is a very succinct speculation. I assessed the damage, and they reduced the value of the premises by 284 to, was it 4? I can't see it behind my box. It's 400,000. That's a huge spread, and it's very speculative. So the fact that the second number is almost double the first number illustrates the speculative nature of it. It's also conclusory. He does not explain how he came across that at all. And it lacks any foundation or any suggestion that he has the ability or expertise to provide this number. So the other aspect that he says is that there was some demand letter he purportedly got. Again, it's hearsay because he does not prove up any business records, and it is unauthenticated. We do not know where the document came from or anything like that. So they do not have any damages evidence that is competent. Their expert should be stricken for being either irrelevant or offering nothing but a legal opinion. And we do believe that it is the court's ability to interpret as a matter of law the definition of gross sales and determine that this is a situation where they do not have a breach of contract at all. Thank you.
Response?
Thank you, Your Honor. I also have a PowerPoint, and
Okay.
so if you'll give me just a moment to pull that up. Oops. I'm having an issue here. Hold on.
It looks fine. I can see it fine.
Yeah, I'm trying to start the animation and I'm having trouble with getting it from under the, I think this is it. No, the Zoom toolbar is getting in my way. Here we go, slideshow. There, okay. Can you see the slideshow now, Your Honor?
Now it's no, I can't. Now it's not properly centered. I can only see like a third of it or
Okay.
half of it. It was working fine before, but then you did something. No,
Yeah, well, that is what happens when you do it yourself, Your Honor. Hold on.
it's okay.
Oh, goodness. Okay. Share screen. Okay. Is that visible now?
It looks perfect.
All right, thank you, Your Honor. So briefly, I did want to respond to the points that Mr. Bowman has made. And in this matter, there is simply no available summary judgment for the plaintiff. There are fact issues on each of the counts that the landlord has raised. They are strong claims for the failure of the plaintiff to pay the rent that they owed and cheated the landlord out of the rent they were owed through accounting trickery, and also for the extensive property damage they did on their way out the door. And when we talk about the underpayment of rent, Your Honor, here, what we learned in discovery and what was withheld from the landlord the entire time that this tenant was there is that they were reporting only 2/3 of the money that they collected from customers in sales as gross sales and paid percentage rent only on the 2/3 that they reported. And so here, Exhibit 39 is one of the financial statements that the landlord obtained in discovery in this case only after the court ordered the plaintiff to produce their financials in support of their speculative lost profits claims. And what we learned when we got those financial statements, Your Honor, and this one's for 2015, it's representative of what they earned in 2016, 2017, 2018, is that they only reported the income line, which in 2015 was about 14.7 million. They didn't report the line immediately below it called advertising income, which was another 7 million. So they left out 1/3 of their sales. And the way they justify that, Your Honor, advertising income in this case doesn't mean money that they got because they ran advertisements for people. Advertising income, by their own admission, is money they collected at the register for products that customers bought in the store that happened to have been mentioned in the circular that the plaintiff distributed through the Dallas Morning News. They say, we don't have to tell you about those sales. We're not trying, as the landlord, to collect the amount of the discount. We're simply saying the revenue you got is part of gross sales. If you followed the plaintiff's version, they could have marked down every item in the store by a penny and advertised everyday low prices and then claimed that they didn't have to pay percentage rent on anything that they sold. That's not what this lease means. As Mr. Bowman said, the lease was entered back in 1963 with Safeway. The shopping center hadn't even been built yet. Nobody knew how successful it would be. And so the parties at that time agreed to a percentage rent so that if it was successful, the tenant would make money, they would pay rent based on that. If it wasn't a great shopping center, they'd have a lower rent. That's what percentage rent is all about. Now, in this case, Your Honor, the plaintiff also received something that they categorized as.
Let me ask you this. Can you show on the screen, if you don't mind, the lease again, the exact language of the lease with the exclusion for advertising revenue?
I have excerpted that, Your Honor, for the court.
Okay.
So the language that the plaintiff is referring to, the lease doesn't define gross sales. It only identifies 6 things that are excluded. And they are things.
That's what I wanted to see.
Right. So some of them are sales taxes, and that makes sense.
I just wanted to see that one section. Can you show?
So the 2 that Mr. Bowman was citing are this one, number 5, the net amount of discounts.
I'm not seeing it on the screen, whatever you're doing. All I see is just the first page of the PowerPoint.
Oh, is it not advancing, Your Honor?
Mm-mm.
Oh, I am so sorry. I thought that this was working.
I mean, it looks like a very nice PowerPoint. All I can see is the first page.
Yeah, okay. All right, well, the language that the court is asking about.
Maybe what we should do is let the other side show the language, because I did want to kind of read it a little more.
I apologize.
That's okay.
Bernard, once you're able to share screen, will you pull up slide 2 and blow up the lower left portion of the image? I'm sorry, slide 3. Thank you.
Okay, so
the big highlighted section, the bottom left.
So it says the net amount of discounts allowed to any customer pursuant to any customary and reasonable policy adopted by lessee, included in such discount, but not by way of limitation, the net amount of any discounts allowed by or by way of or resulting from the issuance to customers of trading stamps. They still even have trading stamps or other evidence of purchase for immediate or future exchange for merchandise or other things of value. And then the next thing says merchandise or other things of value issued in redemption of such trading stamps or other evidence of value or issued as premium or otherwise in connection with any sales, promotion, or lessee. So Mr. Bowman, what were they excluding under these 2 sections?
Your Honor, so they would issue these circulars that would promote specific items. For the example I used was the bananas. So if they say, come buy bananas this week, they're selling them for under cost in order to induce people to come in the door to buy the next item that they might buy at proper cost. So they're actually losing money on the sale of the promoted item. And the promoted item was done as a circular for the neighborhood, handed out as a, that's what we're saying as an evidence of value. Come and buy this particular product at this particular price, which is at an actual loss. And so it was those sales of the loss that were excluded. That is what was excluded.
And Your Honor, that's 1/3 of their income, 1/3 of their sales. And as I said, through their interpretation, they could have advertised everything as on sale and reported nothing. What this is talking about are loyalty programs like trading stamps, like when you get stickers that you can redeem for cookware. That's what this is. And they admit they didn't do either of those things. If you play Monopoly at Albertsons or Tom Thumb, you'll get a token And sometimes you can redeem them for a free bottle of aspirin.
Well, the point
Don't
of
have
that,
to-
Your Honor, is the same thing. That's exactly what the whole point of that section is when you're running promotional programs that are costing you money in order to operate, you don't have to include that as the term of gross sales, because that would include in your sales losses. And that's why that whole section is in there. It makes sense, because if you're promoting something at a loss, you shouldn't be punished for that. What the point is that when you're making money, you include that in the percentage rent. That's why those sections are there, is so that loss programs don't get punished.
Your Honor, they're still making sales from the store, collecting money at the register that goes into their pockets. That's a net economic benefit to them. Now, the fact that this is not defined as net income, it's gross sales.
With specific exclusions.
But Your Honor, what this is referring to are, you don't deduct from gross sales. You don't have to report as part of gross sales the value of the trading stamp. You don't have to give it some sort of value and add that to what you report. And you don't have to report the value of the cookware that you issue to people in redemption. The language that Mr. Bowman's ellipsed out in his analysis is the part that says issued in redemption of such trading stamps or other evidences of value, or issued as a premium or otherwise. He took that out, if you read his brief, in order to try to cram this program that they claim.
So I guess this is really unclearly worded, but it says merchandise or other things of value. So we ellipsize out merchandise. What modifies what here? Merchandise or other things?
Obviously, I don't think the ellipsis is necessary. It was for ease of understanding, just so that we don't lose sight of arguments about trading stamps and things like that, because that's the only phrase that's in there. I understand. But the language of this is designed to exclude promotional programs. That's what it's talking about. Any sales promotion program of lessee.
So what I'm getting at, so if you could just let me finish my thought.
Yes, Your Honor.
It says merchandise or other things of value issued in redemption of such trading stamps. And then should it be or other evidence of value? Does or other evidence of value modify the previous statement, merchandise?
Yes.
And then
so that section right there, those 5 words of or other evidences of value, I believe, refers to the merchandise and other things of value issued in redemption.
Okay, so that would not apply here then, right?
Say again, sorry?
That would not apply here.
No, I think that the merchandise that is sold in redemption, I think that's the whole idea, is it things of value that are issued in redemption of the well, actually, I'm sorry. The problem is I can't see it because I show my person.
And then it goes, or issued as a premium or otherwise in connection with any sales promotion program or of lessee.
Right.
You see what I mean, this really is unclear what this means. So what you're trying to say is this issued as a premium or otherwise in connection with any sales promotion of lessee is just kind of standalone phrase and not modified by the previous phrase?
No, I believe that in this case, for example, other things of value issued in redemption or as a premium or otherwise in connection with any sales promotion program of lessee. I think that's the concept of it. And so in this case, what we're talking about is what was sold based upon the circular, which was issued as a sales promotion program. That's the whole concept of it. That's the structure of it. I mean, I think that this was written in the manner that it was, not in order to be ambiguous, but to cast a wide enough net to protect these sales promotion program concepts for the tenant, so that if they're selling things at a discounted rate that's causing them a loss in order to bring customers in, they're not going to be punished for that by including that as gross sales.
And Your Honor, we don't believe that's a reasonable interpretation of this provision. And it's targeted to specifically, you don't have to give a dollar value to the tokens or other evidences of value that you issue. And you don't have to pay rent based on the merchandise that you give to people to get them into the store as part of your promotions. If you look at the other exclusions.
So let me ask this real quick. So when you look at the beginning of 6, it says merchandise or other things of value issued in redemption of such trading stamps. So if there was a trading stamp promotion, then, and you got a, free popcorn maker, then because of that, then that would be excluded. And then the second one would be, or other evidence of value, that would be, I think, also so I don't know what that means, but let's say there was some other program like a Monopoly program or whatever, I guess that would be also in redemption. If you gave out something because of the redemption of that thing of value, then that would be covered by 6. But then it says, or issued as a premium, or otherwise in connection. I'm trying to use kind of like, how do you break down this sentence? Because it to me is just very unclear what it's supposed to mean.
Right. Your Honor,
What modifies what?
Well, I think that the first of it, the merchandise or other things of value, is the beginning of it. And in that case, it's issued in redemption of such trading stamps or other evidences of value. That's another statement. Or issued as a premium or otherwise in connection with any sales promotion program of lessee.
What does it mean, or issued as a premium? What does that mean? Give me an example of or issued as a premium. What does that mean?
I suppose in that case, maybe a specific coupon for a specific item. I have not personally focused on the premium aspect of it. My client's position was that it was the things of value that were in connection with the sales promotion program of lessee, that was it. It was the sales under the promotion program that were specified in the circular, because those were done at a loss. And that was the concept of what this section was. I mean, that was what they understood this 5 and 6 to be, was you can operate sales promotion programs in order to induce people to come into the store and make actual profits, and that those sales will not punish you. And that's why gross sales has this exclusion.
Yeah. Your Honor, if I may, premium could mean, for example, a buy one, get one free promotion. You don't have to count the value of the one that's given away towards your gross sales.
But again, there's no functional difference of when you get to the point of what it is that they're doing when you do a buy one, get one free. Is the idea is when you are operating a program and that is causing you a loss on items, you don't get punished for that program. That's a sales promotion program of lessee. That's what the circular did. It was a sales promotion program.
So did the circulars, I assume, will be like, okay, you can get bananas for 20 cents a piece,
right?
And they cost 25 cents a piece. There'd be a loss, but wouldn't the 20 cents itself, the gross sales wouldn't include the 25% because that's not what they actually got. But if they got 20 cents for the banana, then that should still be included in gross sales, shouldn't it? Or by your analysis, no.
Your Honor, the accounting level of that is certainly beyond me. My understanding of the way that they operated their accounting income is that what they provided for was the discount under this section. So when we're getting down to the brass tacks of the 20 cents versus 25 cents, that's not what their argument is. Their argument is this section doesn't apply at all.
Yeah, and Your Honor, to your point, exclusion number 5 says you don't count the net amount of any discounts. And so that's where the concern you've raised is addressed. You don't count the 20 cents off, but you do count what they actually collected from the customer at the register as part of gross sales. And that's where we disagree. And we believe we have the better interpretation, Your Honor, but definitely for sure, the plaintiff hasn't established as a matter of law that they're entitled to summary judgment on this count.
Well, Your Honor, that I disagree, because what she's talking about, you include the 20 cents. Well, all of a sudden you're including losses. That's the whole point that what she's saying. And their brief, if you read it, in their claim, asks the court to ignore that exclusion, both of those exclusions. That's not saying that we calculated it wrong. They're saying that we did it at all, and it shouldn't be done at all. That's the reason that this is a summary judgment situation. The definition, it exists. It's in the contract, and they're saying it shouldn't. And I mean, every time that they want to try to get the court to rule on this, they have to come up with an alternate hypothetical than the actual facts that exist. The facts that exist is that these definitions are there. They are exclusions from gross sales, and we properly excluded them.
So let me ask this. Is there anyone here on the JAG case?
Yes, Your Honor.
Do you guys still need this hearing, or have you guys resolved everything?
I haven't heard from anybody at his firm, but I'm happy to try to resolve it, Your Honor.
Do y'all want me to put you into a breakout room so you can try to resolve it?
That'd be great.
Sure, Your Honor. Thank you.
Okay, just come back whenever you're ready.
Thank you.
I'm going to assign you guys now. It's just Grant Schmidt and Misty Broom, correct?
Yes.
Yes, Your Honor.
Okay, so you only got to the first page of your PowerPoint. Did you want to still try to use that at all, or no?
Your Honor, there's only one other thing that I would like to be able to show the court at this point, and that is, well.
Your inbox?
Sorry. I was going to show the photos that are in the record of the damage that the plaintiff did to the property on their way out the door. Yeah, I heard Mr. Bowman say that there's no evidence of damage. There is. It's extensive. And what we've established, Your Honor, is the fact of damage beyond any doubt. The question
is there a contractual provision that discusses how property damage should be allocated?
There are two, Your Honor, that I would direct the court's attention to.
Okay.
One is a provision in the 1963 lease that does address the tenant's right to remove their equipment and fixtures at the end of the lease term, but requires them to repair any damage that's done. And if you look at the photos that we've submitted, there's clear evidence of ceiling tiles being ripped out. They removed their display cases, but didn't repair the damage to the floors. So there's
for the contractual provisions, though. You said there were two.
Yes, that's in the contract. And
okay,
then
can I see those contractual provisions?
Well, Your Honor, as you know, I'm having trouble displaying the contract.
What provisions are you talking about? What sections? And maybe Mr. Bowman can show those.
This is in the 1963 lease, paragraph 9, and we excerpted it in our brief, Your Honor.
Your Honor, I don't think I have the entire contract available, unfortunately.
Okay. It looks like we're kind of running out of time. We're having technical difficulties. When is your trial setting on this case?
I believe it's in the summer, Your Honor.
It's in the summer.
Why don't I do this? I'll take a look at it. Why don't you email me both of your PowerPoints, since we had some difficulties seeing them, and email those to me. I'll try to get you a response within 4 weeks.
Directly to Your Honor's email address?
No, I'm sorry. Email it to my court coordinator. Okay. Anything else, guys? Oh, did you give me a quick argument on the fraud by non-disclosure, Ms. O'Connor?
Yes, well, we've established all of the elements of the claim, Your Honor. The arguments Mr. Bowman made today weren't raised in his motion, and so they wouldn't be proper for the court to dispose of the claims on that basis. What we've established is that the plaintiff provided half-truths. They made a disclosure of what they said their gross sales were, which weren't accurate. They never told the landlord what they were keeping out, and that it was a third. The argument that the plaintiff made in their motion was that we hadn't established materiality. The information they didn't disclose was fully a third of the sales they were making from the premises. And so we do think we've established materiality. It was important for the landlord to know what kind of tenant they were dealing with here. The claim the plaintiff has made is that they were entitled to stay, that they, were misled by the landlord in lease negotiations. The landlord would never have dealt with them at all in lease negotiations if he had known how these tenants had cheated him over the years on the rent for this place. And we have the testimony of their bookkeeper, who's also an owner, which is in the record, in which he says, you know what? We made money from this store. We had distributions that we got as owners from this store, unlike our other stores, not because the sales were higher, but because the rent was so low. Well, they made that happen. They made that happen by their creative accounting, by their non-disclosure, and I think a jury needs to hear it.
Okay. All right. I will take this under advisement, and we will try to get you a decision within 4 weeks.
Thank you, Your Honor.
Thank you. All right, Ms. Rima, are you there?
Hi, Your Honor. How are you?
Good. Are you here on the Valencia case?
Yes, Your Honor.
And is it your opposing counsel here?
I'm here, Your Honor. Chastity McNair for the plaintiff, Ms.
Right.
Valencia.
Great. Are you guys ready to get started?
Yes, Your Honor.
And is Mr. Green, what are you here for, sir? Greg Green? Is he involved in this case? Ms. Rima or Ms. McNair, is he one of your co-counsels?
No, I'm just standing.
Sorry,
I'm just
Your Honor,
standing by for the
my
glass
connection-
cock. Should I get off?
For what's glass cock you said? Let me see.
Yeah. The Jag. Sorry, Jag.
Jag, okay. Yeah, I think I sent him to a breakout room. Do you want me to send you to that?
Yeah, sure. That'd be great. Thank you.
Let me see if I can. Okay, I just sent you an invite.
Thank you so much, Your Honor.
All right, so Tony, you ready? Tony?
Yes.
Let's go on the record on cause number DC 208948, Andrea Valencia versus Danny Blackburn. Counsel, make your appearances.
Chastity McNair for the plaintiff, Ms. Andrea Valencia.
Stephanie Rima for the defendant.
All right, let's proceed.
All right, Your Honor. I have a 5-slide PowerPoint. Do you mind if I show it?
Sure, if you'd like.
Thank you. Let me share my screen one moment. Okay, are you able to view it?
Yeah, I am. It looks nice.
Okay, awesome. So we're here for plaintiff's motion to strike defendant's counter affidavit of Dr. McMaster, a medical doctor. As you know, Your Honor, there is the Borders v. Heist case that discusses that not every medical doctor is an expert to opine across all medical specialties. So while plaintiff understands that Dr. McMaster is a medical doctor, that does not qualify him to opine as to all of her medical treatment, which is essentially what he's doing. This next slide, you can see on the left side, the medical treatment that my client, Ms. Valencia, received. She received pain management treatment, chiropractic treatment, psychotherapy treatment, and she also received some imaging. I will say that there was one visit at the last visit with the pain management doctor, Epic Pain and Orthopedics. She did see an orthopedic doctor because the pain management doctor referred her there. However, on the right side, you can see Dr. McMaster, who is an orthopedic doctor or orthopedic surgeon. He is opining as to the reasonableness of the pain management treatment that she received, the chiropractic treatment, the psychotherapy treatment, as well as the imaging that was done at DFW MRI and interpreted by Singleton Associates. He's not qualified to do such because he is not in those specialties. Defendants in their response, or defendant, I should say, in their response stated that he is a board certified surgeon, and based on his years of experience in treating patients with similar injuries as my client, that qualifies him to opine as to the reasonableness. However, that's untrue. There is nothing in his counter affidavit or in his CV that shows that he manages, operates a chiropractic facility, a psychotherapy facility that provides therapy, any imaging or radiology facility, yet he is shrinking down my client's medical treatment. And that is the exact misuse that 18.001 is trying to prevent. So him being an orthopedic surgeon, while yes, surely he is qualified to opine as to that and maybe even to the necessity, but he's controverting the reasonableness. And I do not believe that he is qualified to opine as to the reasonableness of charges for other doctors in completely different practice areas than he is in. As far as how he gets to the reasonableness portion, he states that it's his practice, and then also he uses Medicare, Medicaid, and workers' compensation numbers. However, those things are not at play here. I know that there is the North Cyprus case that defendants put in their response as far as reasonable charges and reimbursement rates. And yes, Cyprus states that that reimbursement rate is a factor, it's not dispositive. And 18.001 speaks to reasonable charges. So I don't know how he came up with this information, and he's opining us across to these specialties. So in summary, we're asking for the court to respectfully strike Dr. McMaster for the reasons that I've stated. His opinion is not going to assist the trier of fact, but rather it's going to mislead them. That's all I have, Your Honor.
That was a nice PowerPoint. Thank you. So let me just say this, and I think Ms. Ream has probably heard this speech before. I'm not sure if you had, Ms. McNair, but I handle these all, I see probably, it seems like now like 3 to 5 of these a week, these motions to strike. And so I kind of handle them all in exactly the same way, in a very kind of what I'd say formulaic way. The first thing I look at is it a medical doctor or is some kind of medical professional as opposed to a billing clerk? I will always exclude billing clerks and always strike their counter affidavits until the Court of Appeals or Supreme Court says to the contrary. So I always strike those. If they're a medical doctor, a chiropractor, or some kind of medical professional, then I look to see under Turner v. Peril, is it like to like? So is a chiropractor can counter a chiropractor, a orthopedic surgery can counter an orthopedic surgeon. So I'm pretty strict about that. And then I also don't allow in any evidence of Medicare, Medicaid, anything like that. And so for this doctor, it appears like the orthopedic surgeon would be Is he like to like as to any of the I guess maybe the pain management clinic, clearly not the chiropractor or the psychotherapy or the imaging, but possibly as to the pain management. So let's talk about the pain management.
Okay, are you wanting me to address it or are you
No, let Ms. Rima do that.
to Ms. Rima?
Ms. Rima.
Okay, thank you, Your Honor.
Thank you, Your Honor, for letting us know what your opinions are on these things for future. As far as in this case, for the pain management, it's Epic Pain and Orthopedics, and this was a facility that had an orthopedic surgeon and a pain management physician involved. The injuries in this case are involving knees and shoulders and treatment to these body parts that an orthopedic surgeon provides those treatments. And within that facility, at the pain management facility, it's Dr. Chun, who's a pain management physician, and then Dr. Saudi, and he's the orthopedic surgeon. I believe that they both were providing treatment in this case. And Dr. McMaster has a familiarity. He's familiar with treating patients in pain management physician facilities because he works in a private facility that does these types of treatments. And so he does, I feel like he is qualified to opine on the pain management treatment.
Okay, response.
Yes, Your Honor. So I just want to point out that Epic Pain and Orthopedic does have pain management doctors and an orthopedic doctor. My client, Ms. Valencia, had one visit with the orthopedic doctor, Dr. Sadie. The last visit in June of 2020 was the only visit that she had with the orthopedic doctor. Defense counsel states that Dr. McMaster works at a facility. However, in their response, they state that he has rights at 2 hospitals and that he works at Glen, I believe it was Glen, where is it? Can't think of the name of it. Oh, Glen Lakes Orthopedic Clinic. So it's an orthopedic clinic. It's not pain management. So my position is that the one time that she does see an orthopedic doctor, it's at the end of the treatment because the pain management doctor referred her. And for where Dr. McMaster works, it's also an orthopedic clinic. So I do not believe that he's qualified to opine as to reasonableness of a pain management doctor.
Response.
And Your Honor, he provides these types of treatments. I mean, he's an orthopedic surgeon and he provides injections and he provides pain management treatment. And in that same facility, they have an orthopedic surgeon that does these types of treatments.
So I'm sharing the screen right now. So it's Epic Pain and Orthopedics is what we're talking about, I guess, right?
Yes, Your Honor. And
Yes,
that
and even the name of the facility is an orthopedic facility as well.
Yes, and the last visit.
And I'm very familiar with this facility.
You guys are kind of talking over each other. Let me hear from the plaintiff's attorney right now.
The June 24, 2019 visit is the visit that my client has with the orthopedic doctor. So yes, the facility has different doctors, but they all have different specialties. So the pain management doctor referred her to see the orthopedic doctor and she had one consult with them.
So let me ask this, how does he come up with these numbers? Let's see.
Your Honor, my side is unstable. So
Your internet seems to
I'm
be
not
unstable.
hearing much.
Okay. I'm reading this.
I'm sorry, I didn't get Ms. Rima's comments. She was.
Yeah, I couldn't hear either.
I was saying that my system seems unstable, so I couldn't hear anything.
Okay.
I was asked if you asked me something. And Your Honor, even in their medical records, they say that Epic Orthopedic Clinic consists of a team with pain management and spine orthopedic specialties. So, I mean, they hold themselves out as an orthopedic facility as well as a pain management facility.
So what I'm trying to figure out right now, and what I'm inclined to do is allow him to counter that one orthopedic charge, but I'm not sure how he gets to his evaluation that what's a reasonable value. And it looks like he has some kind of algorithm or something based on CPT codes, RVU, CF. I'm not sure I fully understand this.
Yeah, he uses, and at the end of his report, he lists the authorities that he uses, which is Fair Health, the Practice Management Information Corporation medical fees, based off of the CPT codes. And so it starts with the conversion factor, and then also with the relative value unit. And there's three components of that. It's the physician work, the practice expense, and then the small components, which are the professional expenses. And those are set values.
So each CPT code has a relative value unit assigned to it when multiplied by a conversion factor and creates the monetary compensation level for particular services. To understand more fully, the calculation can be broken into two components, RVUs and conversion factor. Physician work, so they have RVUs. So it relies on the amount contracted with an entity. Is that how I'm seeing this?
That's how I understood it, Your Honor.
Because he says, therefore, when I review a record, I will define the maximum reasonable cost for service as a product of the equation RVU times CF, the amount charged by the practitioner or the amount allowed by a commercial or a governmental entity, which is paid to a practitioner who is contracted with that entity. Okay, so I guess I'm just looking at his affidavit. He does a different report. Okay, let me see the report. Wow, this is really long. Okay, let me go through this. Huh. Okay. All right, I'm going to allow you to counter. I'm not sure I fully, this is a little more complicated than I usually see, but I'm going to allow you to counter that one orthopedic visit, but the rest of it's struck.
Okay, Your Honor, can I make one comment?
Sure.
Plaintiff's counsel mentioned that this isn't going to assist the jury, but the thing is this counter affidavit doesn't go to the jury. The purpose of 1801 is for us to be able to cross-examine plaintiff's experts, and we're not asking that this affidavit go to the jury. We're just asking to have an opportunity to cross-examine the experts.
And let me make one thing clear is that, sure, one thing that I want to make clear is I'm not striking the expert. I'm just striking the counter affidavit. So if you want to call your expert to testify about all this, you can. So this is not a ruling as to that. Okay. All right. Just
okay, so I can still call.
You can call your doctor live if you want, or by deposition. I'm not striking your expert. I'm just striking the counter affidavit.
Your Honor.
Okay, so he'll be able to testify in his deposition about what he finds reasonable in his method, and if plaintiff's counsel wants to move for a dauber on the relevancy and reliance, that's
sure. That would be to me, there's two different analyses here. One is, do you strike the counter affidavit? Two, if you strike the expert. I'm not saying he can or can't testify. I'm just saying that I'm not ruling that he can't. Like, I think it would be pretty unlikely he'd be able to testify about psychotherapy visits and things like that. That's probably going to be outside the scope. But for the rest, it's something that we'd have to look at for Daubert.
Your Honor, I just want to clarify the testimony that you're talking about. Is he going to just be allowed to testify as to the orthopedic, or are we talking about
all I'm ruling on today is the counter affidavit. I'm not ruling on anything involving whether or not this doctor can testify. So my only comment is I'd have to look at that under a Daubert analysis, not on their alternative peril analysis.
Okay. Yes, Your Honor. Thank you so much.
Thank you, Your Honor.
If Ms.
And
McNair,
Your Honor, I have one question.
Just 1 second. Ms. McNair, if you could go ahead and submit a proposed order to Ms. Rima and then email that to the court. And then did you have another question? And then I need to let you guys go.
That's all. We'll do the proposed order and get that over to you, Judge.
Okay. Ms. Rima, did you have a quick question? Ms. Rima?
Yeah, I actually had a question on another case. I saw you on last week. I'm not sure if you remember, but you that my expert can counter after the designation deadline, and I filed a motion for leave for my expert. We have that motion for leave on next week. I wasn't sure if we still needed to have that hearing.
I'm not sure. I think, is that on Monday?
Yeah.
Yeah, I would think you probably would.
Okay.
Unless you have an agreement on the other side.
Okay, sounds good. Thank you, Your Honor.
You guys. All right. Mr. Schmidt, Ms. Broom, have you guys reached an agreement?
Unfortunately not. Unfortunately not, Your Honor. I think we're going to have to just address a couple of things with Your Honor, hopefully briefly.
So let me say this. I haven't taken a break all morning, so I'm going to take a break. We'll reconvene in about 10 minutes.
Thank you, Your Honor.
Thank you. Okay, I'm back, guys.
Hi, Your Honor.
Good morning, Your Honor.
Good morning. All right, so oh shoot, we were on YouTube the whole time. I should have turned that off. Oh, well. Okay, so we're back. I apologize. It took a little longer than I expected. I had a wedding as well to do. And
Oh,
then,
very cool.
yeah, it was fun. So it's a local lawyer who was getting married. So, all right. So are you guys, you said you still need a hearing, correct?
Yes, Your Honor.
Let me just do one thing real quick. Okay.
Your Honor, if I may offer just one, there's one procedural issue with this, and then if we get past that, there's a substantive issue. But I fully realize it's Ms. Broom's motion. I just wanted to raise that for the court.
Okay, give me a second.
If Your Honor doesn't mind, since I am the movement, I am very happy to go ahead and address that portion and allow him to then respond.
Sure. Give me 1 second. All right, Tony, you ready? Let's go on the record on cause number DC 201463, JAG Financial Services versus Capital Asset Recovery, LLC. Counsel, make your appearances.
Constance Broom on behalf of Plaintiff Jag.
Good morning, Your Honor. Grant Schmidt, along with my clients, Mr. Greg Green and Mr. Gregory Green, representing Capital Asset Recovery, LLC.
All right, let's proceed.
Your Honor, this was initially heard on January 4th. We had a motion to compel along with a bunch of other motions. You probably remember. There were several, and it lasted a lot longer than what the court had planned on. And so at the close, before the court was able to hear all of the arguments in the motion to compel, the judge said, you said, let's address this one portion. If you guys have further issues, then let's come back at 3 o'clock this afternoon or see if we need another hearing. Unfortunately, I wasn't able to come back at 3 o'clock because I had to go get tested for COVID and get treatment for COVID. So I wasn't able to come back. As I understand it, Mr. Schmidt was there. I did email him and let him know that we intended to have the rest of the issues addressed that were in the motion to compel. But they weren't. And so we made an effort to resolve them. And then counsel said that there was no resolution to be had because their position was that the court had already ruled, even though the issue had not been argued or brought up because of time constraints. So we set it again for hearing. And that's the procedural issue that I believe Mr. Schmidt is referring to, because from his position, the whole matter has been litigated. Just because it wasn't heard previously, there's no reason to hear it now because the judge heard the motion itself.
Response?
Yes, Your Honor. So this is somewhat of a unique scenario, Your Honor. The court has ruled on the motion to compel. There's an order on file from January 5th where it says, having considered the motion, all responses, the motion should be entered by granted as follows. That proposed order was a joint order. Ms. Broom and myself submitted it to the court. And then several weeks later, it has now been reset. And so I am, obviously, Your Honor, there are many mechanisms to do this. There are motions to reconsider. There's a new motion to compel. There's motion for clarification. But I've never had a motion that has already been ruled upon by the judge then be reset for a subsequent hearing. And so that is the procedural issue I just wanted to raise with the court.
Ms. Broom, did you agree to the form of that original order?
I agreed to the form, but had already communicated with Mr. Schmidt that this portion of the motion had not been addressed and that we would have to have it addressed, and that I was hoping that we could resolve it. And so the order was submitted with the understanding that that portion had not been heard. So the portion that's at issue now is just the portion that I told him about before the order was submitted.
Mr. Schmidt, is that true or?
Well, yes. So, Your Honor, there's an email where she says, Mr. Schmidt, there was one thing that I didn't raise with the court. Surely we can reach an agreement on this. I mean, I can pull the email up.
Why don't you pull up that email so I can see what you're talking about?
One second, Your Honor.
Additionally, Your Honor, before I signed off on the order, he presented it to the court at the 3 o'clock hearing. I was not able to be at that hearing, as Your Honor knows.
I know I did not do that. Your Honor, at that hearing, I said, Your Honor, Ms. Broom has told me that she is receiving a COVID test and we should probably revisit. And you said, that sounds great. Go talk to Ms. Broom. Let's try to get an agreement. One second, Your Honor. I just want to pull this up and then we can move on.
I mean, it sounds like I should probably hear this. It's up to y'all. I kind of agree with Mr. Schmidt. This probably isn't the right procedural way to do it, but
Your Honor, tell me if you can, let's see here. Okay, Your Honor, can you see my screen?
yes.
Okay, so this is the email, and like I said, we can move on, but thanks, Grant. Given the court's time constraints, we didn't have time at today's hearing to address the missing notes that weren't included in the spreadsheets. Obviously, we just agree with the characterization of that, but I'm hopeful we can work that out between ourselves. And then we entered the agreed order. So that's all I was conveying to Your Honor, and I think we're now on the same page.
Okay, so you want to just go forward with that now?
Your Honor, I'm more than happy to. I just wanted to present that to the court that I've not had a motion that has been fully ruled upon by the court reset. I've had motions to reconsider or motions to clarify or
I get it.
But more than happy, Your Honor, to move forward.
Let's move forward. Ms. Broom, make your argument, please.
Okay, the first argument is the fact that, as Your Honor remembers from the previous motion, one of the arguments that counsel made on behalf of CAR was that the issue regarding producing debtor files associated with CAR 0000140 was moot because counsel was already in the process of producing them to us and had agreed to do so, which is true. Counsel had agreed on November 20th and agreed on November 25th to produce those 5 files. And so the motion should have been moot, but the items had not been produced yet, which is why we had to file the motion to compel. In response to that, counsel's argument was, look, it is a moot issue, really. CAR is going to produce these items and we'll get them to them. We never got them. So in follow-up with counsel about that, his position was, well, these are available at CAR's offices. The other items that the court did order that we could go and look at are there too. Why don't you just do it all at the same time? The problem is, Your Honor, and this is just so typical of this pandemic world, unfortunately, is that since the hearing, my clients have become the sole caretaker of Miss Glasscock's father. He's almost 90, but he's in end-stage kidney failure, and he has dementia, and he's been diagnosed with COVID. And so at this point in time, and since that hearing, they've not been able to go, and for the foreseeable future, they are not going to be able to go and rummage through CAR stuff. And honestly, I don't know that CAR would want them doing that, considering they are prospectively contagious. So at this point, that's not a possibility. That was conveyed to counsel. Also, I believe that my boss emailed counsel and let him know that it was against her company or the firm's policies to send employees to sites where they could be potentially exposed at this point in time. So that's why I'm working from home. So we let him know that. And notably, at no point in time have we asked CAR to produce all of the other files that were at issue. We're only asking for the 5 files that they said back on November 20th, and then again on November 25th, and then again to the court that they just produced those files. It's 5 files. And so we were asking that they do that since they'd already agreed to. And I don't think that we should be put in a position to endanger anyone at CAR or ourselves by going out in this pandemic world unnecessarily when Mr. Schmidt has indicated in his deposition and the deposition of my clients that those files are in his possession and control.
So, Your Honor, may I share my screen?
Sure.
So, Your Honor, this is the order that we agreed to and the court entered. We, based on the court's ruling at the last hearing, we agreed that they could have access to the room in which all these files are maintained. That includes those 5 that we could go look for. That includes all of the hard files that they've asked for. Anything in our possession is in that room. And so I understand this point about COVID, but Your Honor, it would require us too, right, to go in a room. So what we've told them is, and what I'm telling you now, Your Honor, is that no one will, we can have a camera set up in the room if their concern was that there was going to be someone, because as you can see in this order, there was going to be someone supervising or monitoring, to protect the proprietary information. If that's the concern, we can set up a camera. We can have someone outside the room. But, there are many ways to eliminate any COVID concerns. And also, Ms. Broom could go look, or Ms. Ramsey could go look, or they could hire someone just like they hired an expert for another portion of this case. And so this order was agreed to. COVID didn't happen after this order, of course, Your Honor. And so obviously I'm sensitive to their father-in-law or the father's health conditions. Maybe we wait until everybody feels like they can do it, but this was the best way. We all compromised and figured out a way to resolve this, was give them access to the room so that they don't have to worry about paying all the costs of copying, all these other things. And that way, they can have their own access and be able to represent that they've been able to look through it. And so,
sounds good. What is your response to that, Ms. Broom?
Response to that, Your Honor, is that this order addresses the other items that were the extensive number of debtor files that were named in all of the other spreadsheets. This issue was not even argued at the hearing simply because Mr. Schmidt's position is, look, Your Honor, I'm not even here on this. We're getting them these files. This is a moot issue. If it's a moot issue, it wasn't subject to being ordered, and the parties agreed at the time in the hearing, oh, okay, well then don't worry about it. Y'all are agreed on that. Moving on. So if that's the case, this order doesn't cover that.
Well, Your Honor, it does. So those 5 files, we could go, again, that is a part of this entire that was just a sampling, right?
Is the real difference here about, I guess I don't understand what the dispute is the difference about whether or not you need to go down and get these out of this room, or what is exactly are we fighting over at this point?
Because my boss will not allow employees to go and my clients can't, and because Mr. Schmidt has promised 2 times before and before the court that this would just be given to us, and now he's changing his mind. That's the problem.
Mr. Schmidt?
No, Your Honor. So again, I haven't changed my mind on anything, Your Honor. They have, I guess I'm confused too about what we're disputing. The court ruled on this before. I mean, we obviously disagreed with the other side on this issue, and the court said, can't we reach some sort of an agreement? And then we figured it out where, even though we don't think that they are entitled, we'll give them access to the room. That includes the 5, that includes the 1,800 that are referenced in another document. That includes the other 100 in another document. So they have access to everything that we have, and that is in that room. I don't know what else I could do, Your Honor.
So Miss Broom, then you don't want to send somebody to the room. You just want him to find the documents and give them to you. Is that the deal?
According to the deposition questions and the items that he addressed with my clients, the repeated statement was, I have these files, I've seen these files. And so when I'm told that on November 20th, told that again on November 25th, and we're getting these to you, we have them, I've got them, I'm going to get them to you. I agree. Then not to do so, forcing me to file a motion to compel, and then saying, oh, well, don't worry about it. This is a moot issue, Your Honor, because we're already getting her these files. So that isn't even part of this order because it wasn't something you ordered on, because the parties were right there.
What was the purpose, I guess, of again, I wasn't here for this part of it. So the third paragraph where it talks about the cost of having an agent to monitor access to the hard copy, what was that supposed to be about?
That was for several hundred other files that were in question, because there were 3 spreadsheets that were produced. The first one was CAR 140. It only involved 5 debtors. Those are the ones that counsel agreed to provide the files for, because they were just 5 of them. The other ones were extensive number, and they were allegedly outside or in a car storage facility. And so what the agreement was that instead of CAR having to go and pull all of those files that would go with these corresponding spreadsheets, they would open that up to allow my clients, with supervision, that they would share the cost of, to go and make the copies, which was fine as to all of those others. So I think that's notable here, because I'm not complaining about that.
Ms. Broom, the previous paragraph says, and again, I'm just reading what was submitted to me and you guys agreed to, it says, CAR is ordered to produce JAG financial access to the hard copy debtor files responsive to JAG's first request for productions 1 and 4 and JAG's first. So there wasn't an agreement that they would produce those. They were going to provide you access according to this order.
That was for the other spreadsheets, though, Your Honor, because remember, counsel agreed that this was moot as to the 140, and the judge, you didn't even hear arguments on it, because he was like, look, Your Honor, you don't even have to hear anything on this. We're giving them these files. So we moved on. So now to come back is a little bit disingenuous to say, oh no, remember, that's going to be part of it. That's my problem, is it's disingenuous when you take the position, don't worry, Your Honor, you don't even have to rule on this. We're giving them these files. And then you go and address the other ones, which were
Did they say that they were giving you the files or providing you access to the files?
giving us the files. It was always, I'll send them over. I've got them.
No, okay.
And those are actually attached to the motion to compel. There were 2 emails, November 20th and November 25th. At both times, he advised that he would provide them to us.
Your Honor, so just to be clear, I never said that I have the files. The question she's referencing in the depositions, I'm talking about the Excel spreadsheet files, because that is what my client uses all the time. In the emails, I said, Misty, I think this is moot, because we can, to the extent we have them, we can locate them, we can get you those 5. That's more manageable. Then, Your Honor, we agreed in this proposed order to provide access to all of the files that were in dispute.
So for the 5 files, you said you would give those to them. Have you given those to them?
Your Honor, we have not searched for them yet, because they have access to the entire room. We can.
Okay,
I can go search for those 5.
So what I'm going to order is you're going to provide those 5, and for the rest of the documents, they have access to them through the room.
Thank you, Your Honor.
Sounds good,
guys. Get me an order that states that, and we'll go from there. You guys be safe, okay?
Wait, Your Honor, there's one more thing.
Okay. I only have 30 seconds, so you guys need to get this done.
Okay, the information, there are notes that are supposed to be attached to those spreadsheets. Those are notes kept in the system. Those notes document what was done on every file. The allegation in this case is that my client didn't do anything in the file. Their response is it's all noted in the documents, and we need to get access to the notes. Their position is, well, we can't give you those notes because it would be too tedious, but there's no documentation or evidence of what that cost would be. Their second issue is that it's a moot issue because the letters you sent out were deficient. But the point of that is, Your Honor, our position is those letters were part of CAR's required letters. And so to blame us for it is wrong. So we need the notes to see what was done.
Response.
Yeah, Your Honor. So again, I'm not sure what's in dispute here. We've told them that we can give them the notes, but that it is extraordinary measures to do so. We laid that out in the declaration. It requires someone from CAR to go through and manually export them. Gregory Green, who's the CFO of the company, outlined the process that it would take. He said what it would take 1 to 2 days for the 100 files, and then up to you would basically multiply that by 18 because there's 1,800 files in the other. Under Rule 196.4, which we addressed with the court before, the other side would have to pay for that. We're more than happy to do that, Your Honor, but it is not something we think we need to prove our case. If they want it and they can reimburse our client for the time that it would take, that's fine. And that's the position I've taken with the other side, Your Honor.
With all due respect, Your Honor, just because they don't need to prove their case doesn't mean that they are not required.
The only issue is who pays for this. So
and they've provided no documentation of that. They did provide a spreadsheet that would have included the notes. They just decided not to include it when they ran the report. So we are asking them to rerun the report with the notes. That's all we've asked.
And Your Honor, it's not as simple. I know Your Honor is limited on time. It's not as simple as simply rerunning. That's the whole point. And that's why we had Gregory Green state in a signed declaration, the process. We can, talk in this room about the cost, but it will cost the client some money to do this. That period.
Your Honor, we are more than happy to share the cost with them.
well, I'm going to order you guys to split the cost of that.
Thank you, Your Honor.
All right, guys. Thank you. You guys have a good weekend. You be safe. It's going to be
Your Honor,
safe from COVID and weather. So good to see you guys.
Thank you.
Your Honor,
Great to see you. Be safe. All right.
Thank you.
Thank you, Your Honor.